Hello, my name's Roger Enriquez. I'm an associate professor at UTSA in the College for Health, Community, and Policy, but I'm also a lawyer. And the reason that we are reaching out today is to talk to you a little bit about estate planning. Estate planning is a kind of a fancy word to just basically what it really means is what do you want to do with your estate or your property, your home, your land after you pass away. And so there's been some changes in the laws over the last couple years, and that's really what we want to talk about with you today. So, what is estate planning? Well, it is basically having a plan, right? It's having a plan about what you want to do with the most valuable asset that most families own, which is the family home. And what happens if you don't have a plan? Well, if you don't have a plan, the state of Texas basically decides what happens to your home. Now, the fancy way of saying all of that is that we have the rules of intestate succession. And what that means is that there's some rules that are set up to automatically decide what happens to your home in the event that you pass without a will or any sort of estate planning. What typically will happen, at least in cases where there's more than one child or one heir, is a situation which we call fractionalized ownership. In other words, that ownership is in the hands of a number of different people. And so part of this discussion today is what's the best way to transfer property to loved ones upon our death? Is it a will or is it this new thing called the transfer on death deed? So what happens if you don't have a plan? Well, fractionalized ownership. Fractionalized ownership happens when homeowners do not manage their estate planning, and that leads to a cloud on the title of the property. And what we mean by a cloud here is that fractionalized ownership. Now, subsequent to that, you could have other things that go wrong. For example, people don't pay the property tax. The house falls into a state of disrepair. So the city files liens on the property because it's a weeded lot, for example. They don't cut the grass, or there's other issues with it. They may even, if the condition gets really bad, they may even try to demolish it because it's an unsafe structure. So here's an example of how fractionalized ownership can occur and its consequences. Let's say that Maria and Luis buy a home at 123 San Antonio Street. Well, this is easy. They both own 50% of the property. But let's say that they have three children. Okay, so Luis and Maria have three children, but Luis also has two kids from a previous marriage that don't live in the home. Right? So those are the three kids, and then, of course, Luis's two. Now, there's two things that we can't avoid, and that's death and taxes. So we're all going to die. So what happens in the event that Luis and Maria should pass away? Well, their ownership in the property would be divided evenly amongst the children. However, it's not, if they died without a will and they didn't have a plan, you'll notice here that something very interesting happens, right? So there's the 50% that belong to Luis and the 50% that belong to Maria. Well, Luis had five kids, so his 50% goes 10, 10, 10, 10, right? Across the 5, okay? And Maria's 50% just goes to her 3 kids. 16.6, 16.6. I mean, there's a rounding thing here, but you get the idea. So what ends up being the situation if they died without a plan or any kind of idea of what they wanted to do? Well, you have 3 kids that each own 26.6, and then you have 2 kids that each own 10%. That's what we call fractionalized ownership. And you go, well, no, I mean, that's okay because I want my kids to each have, a little something. Well, true. I mean, that's probably a good idea, but do you realize now, how are they going to reach any kind of decision? Let me give you an example. First of all, who's going to live in the house? Okay. All right. Who's going to pay the taxes? Who's going to make the repair? See what I'm saying? All of a sudden, you have to have 5 individuals deciding. And as my clients have often told me, it's not my kids that we're worried about. It's the husbands and wives of my kids that we're worried about, because now they get a say in what happens to that house. I guess that you can see very quickly that this can lead to all kinds of problems, and they're problems that can really be easily avoided. Think of the consequences. There'd be unpaid taxes, liens on the property. The home could fall into a state of disrepair, and all the hard work, think of all the blood, sweat, and tears that you put into that home, are now lost because no one is really responsible for the home. So the reality is that we want to avoid all of that. The consequences is, instead of the original 2 owners, Maria and Luis, declaring who gets the property, the 5 children have to come to an agreement and sign all the necessary documents. That can be very troublesome and expensive. If the children, for example, agree to sell or give up their share to the property, all those agreements have to be signed in some sort of legally binding document and recorded in the Bexar County Court of Records. If the children, let's say that they never even met one another, or they've only seen each other at a few occasions, they now have to spend time trying to find each other, and it could take weeks, months, even years before that property's title ever gets clear again. So consider this. You're an original owner like Maria and Luis, and you a secondary owner like the 5 children. Are you in a more complicated situation? Because what if one of those kids dies? It's possible that one of your children could predecease you. And now it's no longer just the 5. It's their kids. So now it's your grandkids that are involved. We've had cases where people have owned 1/48th of a share, right? So you might be saying to yourself, okay, well, what do I need to do now? We're very fortunate that the state of Texas passed a law that makes it possible to transfer the title on real estate fairly easily upon your death. It's called the transfer on death deed. And it's simple and it's revocable too. So the transfer on death deed, which you can see there in a sort of what they look like, it's a 2-page document. As you can see, the very front of it says revocable transfer on death deed. It literally only has effect if and only if you die. And once you die, title passes to your beneficiaries automatically. And the way the state of Texas has set it up is you have your primary beneficiaries, and often what we see is couples decide to make husbands primary beneficiaries for wives and wives primary beneficiary for husbands. And in the event that they're both gone, then they select one, possibly two children to be the alternate beneficiaries, right? And they're really very straightforward documents. People often ask us, well, what do you need in order for me to do a transfer on death deed? All we need is the first and last name of your primary, right, and your alternate beneficiaries with their complete addresses. Now, normally, it would cost between $30 and $60 to record these documents. But because of the assistance of not just Councilwoman Shirley Gonzalez from District 5, but County Commissioner Justin Rodriguez from Precinct 2, they've made some funding available in order to have these documents recorded. But you need to check with your agency to make sure that that's still available. Listen, I want to thank you for your time. I hope this has cleared things up. And if you have any other questions, just please feel free to follow up with us. Have a great day.